Okay, we are now live. Oh, whoopsie doozies. What happened there? Let's just turn this light back on, shall we? Whoa, that's a bit bright. Hello. We lost it again. Oops, what's going on here? Hello. My name's James Dapperchi. I am a solicitor at the firm Chamberlains. The logo just here, which is good fun. And team, today we are going to have a chat about standing in the company's shoes, which is a bit of a line that I've used to describe derivative actions. And if you don't know what those are, don't worry. We're going to discuss it together. We'll figure it out as we go. Now, we're probably going to chat for about 50 minutes or an hour today. Can I invite you, please, to make comments however you feel you'd like to, as Bronwyn has just there. G'day, Bronwyn. How are you? Thanks for your comment. G'day, Mina. How are you? Thanks for joining us. And so as we work through today, please don't hesitate to, if you're on Facebook or if you're on YouTube or if you're on LinkedIn and you feel like dropping a little comment or asking a little question, please go ahead. Now, we're also going to be recording this session. And so in a little while, and I don't know when that is, and that's my fault, and I'm sorry, this is going to become a podcast episode as well for the Chamberlains podcast. Okay. We will get started very, very shortly. Just a bit more housekeeping stuff. You are joining me as part of a series of CLEs I'm giving every Tuesday, Sydney time, at 1 p.m. So Tuesdays at 1 p.m. What we do, g'day Lee, hi there, thanks for joining us. What we do is I've got a nice pot of tea just here, which is very full indeed. What we're going to do together is sit down and have a chat for an hour about a bit of corporate and commercial law. I'm going to give a CLE, as we lawyers call them. You're welcome to join in, and we'd love to have you. And thanks for the question here, Mina, about adjusting to the new firm. It's going well, having a great time at Chamberlains. So thank you for the question, Justin. Thank you for your comment. It's very kind as well. So every Tuesday at 1 p.m, we're going to have one of these CLEs. We're going to go live on Facebook, LinkedIn, YouTube. And every Wednesday night at 8 p.m, we're going to do the same CLE on Instagram, at the Instagram page Coffee and a Case Note, all one word. And that'll be 8 p.m. Sydney time on Wednesdays. And that'll be a bit cheekier. That'll be a bit of a late night sort of session. So we're having a nice cup of tea here in the daytime. Then if you prefer the nighttime version, Wednesdays at 8 p.m, we might even have a cheek. Here we are. We're talking about standing in the company's shoes. We're talking about derivative actions. So let's get into it. Let's imagine a company, and let's imagine you are a shareholder in that company, and you are of the view that that company has a claim, that company is owed money, but the company decides, no, I'm not going to chase that money. So what can the shareholder do? Remember, the shareholder just owns shares in the company. It doesn't necessarily control it. And so it can seem like an intractable, impossible problem. How can a shareholder get a company to sue someone? Well, today we're going to talk about the answer to that question. There's a little bit of complexity to it, but in essence, it's going to be a derivative action is going to be the answer. And it is going to be how a shareholder and a couple of other types of people can stand in the shoes of a company and go and chase some money that is owed to the company. So we're going to divide our talk into 3 sections. And Charlene, thanks for asking. Yes, it's a cup of tea just here, so cheers to you. If anyone else is having a cup of tea or a toasted sandwich, please feel free to let me know in the comments. Now, a disgruntled shareholder and a couple of other types of parties, if they are disgruntled about a company not pursuing a claim, not going and chasing some money that it's owed, what they can do is they can apply pursuant to Section 236 of the Corporations Act to stand in the shoes, and I use that term loosely, that's not a technical legal term, of the company. And they can also use just the inherent jurisdiction of the court to stand in the shoes of the company. And as we'll come to later, what we're going to find is that the Corporations Act, so Section 236, is the way to stand in the shoes of a solvent company and probably of a company in receivership. And then the inherent jurisdiction of the court is the way that we stand in the shoes of a company that is in liquidation. So after a company has had a liquidator appointed to it. Okay, so there are going to be 3 different sections to this chat today. Firstly, we're going to talk about the law, right? We're going to dive into the real crunchy stuff, and it's going to be a little bit tough. It's going to be a little bit technical. It's going to be a little bit involved, but don't worry, because once we complete our discussion of the law, we're going to go into discussing some decided cases, and that'll be our opportunity to really dive into some worked examples for how the law looks, putting some meat on the bones, as it were, for how the law looks when the rubber hits the road, when people are experiencing these derivative action issues in practice. And then at the end, I'm going to make some suggestions for some practical steps that you and potentially your clients might be able to take if they're confronted with these sorts of problems. Okay. So let's start with the law. We'll turn to Section 236 of the Corporations Act, and I'm not going to read it out for you verbatim because both of us would die of boredom. But let me just say, broadly speaking, that that section allows a person to, on behalf of a company, bring or intervene in proceedings as they go, or they can commence them at the very, very commencement of the proceedings. And the right of a person to do that at general law is abolished. Let me put that in a slightly more simple way. Section 236 says if you are a shareholder or used to be one, or you're a director or you used to be one, you can stand in the shoes of the company to go sue someone that owes the company money. That's a really broad, simplistic way of explaining it. And so if we have that as our basis, we can work from there. So let me pick out a couple of issues and also just check these comments. Bronwyn is at the gym. Bronwyn, that is very, very excellent. Glad to hear that you've got derivative action watching to do while you're at the gym. Hope all's going well. Lift heavy or run fast or whatever it is. And Mr. Wrigley, the king of going live. James, cheers to you. Hope you're well. So let's just pick apart Section 236 of the Corporations Act with a little bit more detail, a little bit more sharpness. Now, membership of the relevant company you're complaining about, that can be a basis for having standing to bring a derivative suit. But you can be a member or shareholder, similar meanings but not identical, of a related entity to the company. So you don't necessarily have to be a member of the company itself. If there's a slightly more complex corporate structure, you can potentially be a member of one of those other companies in order to stand in the shoes of the company. An officer, which often means a director or a secretary, or a former officer, can have standing to bring the proceedings. They can apply to try to stand in the company's shoes. And if the application succeeds, if the court says, yes, that's fine, James, you can go and stand in the company's shoes, then the litigation, the court proceedings that are on foot, they're not going to be in my name. They're not going to be in James's name. They're going to be in the name of James Pty Limited. They're going to be in the name of the company. So they're just some little matters to consider when you're looking at Section 236 of the Corporations Act. So remember, this is the hard bit as well. If you're feeling a bit confused, don't worry. This stuff's going to make sense. We're going to work through it together. So if we turn to Section 237 of the Act, we now have some slight complexity, some more complexity to add on. Now, we've got some criteria that the court can use when deciding whether or not to grant leave, whether or not to let someone stand in the shoes of the company. And this is at Section 237, subsection 2. There are 5 criteria to look at that the court has to say, right, let's think about these 5 things. when we're thinking about whether we're going to let someone stand in the shoes of the company. First thing they're going to have to think about is the court is going to have to form a view about whether it's probable, whether it's likely that the company is going to do this anyway. So the court has to say, well, we're only going to grant permission to go chase that money if the company wasn't already going to do it anyway. So the court has to form a view about that. The second thing the court must do in order for the applicant to succeed is must be satisfied that the applicant is coming in good faith. We're going to talk about the good faith requirement, as you can imagine, as we progress our discussion. The third thing the court must be satisfied about is it must be satisfied that the derivative action, the permission to allow the applicant to stand in the company's shoes, is in the best interests of the company. The fourth thing that the court must be satisfied about is that there is a serious question to be tried. And the fifth requirement is a notice requirement. And if all that just went in one ear and out the other, don't worry. As I say, we're going to work through this stuff together and we'll all understand it together by the end. And that's fine. There's a rebuttable presumption as well as part of Section 237 that has a little bit of technicality to it. And we won't dive into it too deeply. But in essence, there is a serious question to be tried if sorry, I've forgotten which subsection it is. Yes, it's sub 3. There's a rebuttable presumption that granting leave is not in the best interests of the company if there is what we might call a rational belief test on the part of directors acting in good faith. We don't need to dive into that too deeply because we've only got an hour and I might get a bit too excited and we might spend too long on it. So before we leave Section 237, I'd like to just extract a couple of things for you and I to aid our understanding. If those 5 criteria, our will the company sue or not, is it in good faith, is it in the best interests of the company, the notice, and our 4th criterion about the serious question to be tried, if all those are satisfied, then the court must grant leave. The court must allow the person to stand in the shoes of the company. The second thing to take away is those 5 criteria, is our probability the company won't sue, is our good faith, is our serious question to be tried, is the best interests of the company, and is also the notice being given. We want to hang on to those because, as we're going to find in the cases, the court's going to take some time in working through them. So let's dive into them a little bit further ourselves as we work through the crunchy area of law before we get to some worked examples. So when we're thinking about the likelihood of a company bringing proceedings, this is going to be a question of fact that the applicant has to prove on the balance of probabilities. So what the applicant has to do, sorry, I'm just pouring myself some more tea. What the applicant has to do is to show that it's likely that the company is not going to bring the proceedings that the applicant says the company should bring. And any lawyer worth their salt wouldn't need too much time to have a think about how this might be done. But in essence, what often happens is a letter to the company saying, hey, are you going to sue this person? And the company saying no, or perhaps not responding at all. So evidence that the company's not going to do it on the balance of probabilities. That's how the court needs to be convinced. Now, good faith is an interesting one. What the courts say is that personal animosity and malice in and of itself are not a problem. Because, if you're a shareholder in a company and it's not doing what you want, then you're probably actually going to be a bit grumpy. And so you are probably going to have a little bit of malice, a little bit of personal animus and frustration about you. But that malice and personal animus won't necessarily stand in the way of you proving that you're coming in good faith. It's relatively easy for a shareholder with substantial shareholding to prove good faith if they can say, hey, look, let the company sue this person because if the company sues them and wins, I'll get more money because I am a shareholder. Hello, Paul. Thanks for joining the chat. And so while often you may be faced with a question about, well, does this angry person have good faith? That question can often be answered by asking another question of, well, how many shares does that person own and what do they stand to benefit from bringing the proceedings on behalf of the company, from standing in its shoes? And so if we ask, well, okay, we've dealt with the likelihood of the company bringing the claim, we've dealt with the good faith question, how do we deal with the question of, is the claim in the best interests of the company? Well, that is a question that is to be answered on the balance of probabilities. And when talking about the balance of probabilities, some people say, well, 50-50 or 51-49. No. It is an analysis that we can also spend some time thinking about, but it is what might be thought of as the civil test. For any non-lawyers among us, you would have heard the criminal test of beyond reasonable doubt, an extreme level of being convinced. Well, this is only the civil test. It's only the balance of probabilities. What is more likely than not to be the case? The court has to consider, when thinking about the best interests, would the outcome that the applicant is seeking be better achieved, or at least potentially be achieved, by that applicant bringing a different claim in their own name? Put another way, do they really need to stand in the company's shoes in order to get what they want? That's something the court needs to turn its mind to. And similarly, when we were talking about good faith, the best interests of the company question is not really affected by any question of malice or interpersonal animus. And if we then turn to a serious question to be tried, well, that test is a fairly low threshold. It's similar to the test you might apply to an interlocutory injunction. The serious question to be tried test is one that can be passed with some ease. If you can describe what the claim is, set it out in an understandable way for the court, then you're giving yourself a good chance of the applicant succeeding in the derivative application. And so that's the position pursuant to the Corporations Act, pursuant to Section 236 and 237. But you might remember before we said, what if a company's in liquidation? Well, a company in liquidation can't rely on the Corporations Act. It can only rely upon the inherent jurisdiction of the court. And that means, or in the case of a provisional liquidator, the question's a little bit more open, but again, that's another chat we can have another day. For a company in liquidation who can't rely on the Corporations Act, or I should say, whose shareholders, whose potential applicants can't rely on the Corporations Act, what can those potential applicants do? Well, what they can do, as we've said, is rely on the inherent jurisdiction of the court. And so we then say, all right, well, how do we activate that inherent jurisdiction? How do we take advantage of that in order, if we are shareholders in a company in liquidation, how do we get into a position where we can where we can stand in the company's shoes and bring a claim that we say ought to be brought? Well, there are three limbs to that test for the inherent jurisdiction of the court. The first question is there a solid foundation to the claim? Now, that is a similar question to the serious question to be tried question, and it is so similar that for the sake of our discussion, we'll just call it the same thing. What you've got to say is, hey, look, court, there's a solid foundation for this claim. Here's a bit of evidence. Here's a bit of law. Looks like there might be something here. And you've got to pass that test. The second relevant thing in trying to get the court to exercise its inherent jurisdiction is the attitude of the liquidator. So what the liquidator has to say is going to have a bearing on whether the court is going to exercise its inherent jurisdiction. And so it's a question that is going to be borne in mind. And then finally, practical considerations, such as the financial protection of the liquidator, remembering that we don't want to expose liquidators to unreasonable or unnecessary risk. They are performing a function of the court, an important function of the court, and you don't want to go around throwing liquidators under the bus. And that's not just a personal view of mine. It's also a view that's consistent with the role that they execute as part of their functions. So the financial protection of liquidators is going to be relevant, as well as whether the applicant is going to provide any indemnity to the company or to the liquidator. So is the court going to exercise its inherent jurisdiction? Maybe, because it's discretionary. So the court may exercise its inherent jurisdiction if there's a solid foundation for the claim, if the liquidator's attitude to it doesn't necessarily stand in the way, the court's going to consider the liquidator's attitude, and if the practical considerations relating to the company lead the court to exercise its discretion. Those practical considerations, as we said, being financial ones often, things like, is there an indemnity in place? What's going to happen with the costs? That sort of thing. So, congratulations. This talk is in 3 parts: law, examples, practical suggestions. The law is the toughest part, and we just got through it. So I'll invite you all to have a sip of tea. If anyone's listening along and feels like leaving a comment or saying hello, that's very, very welcome. I'm going to have 2 sips of tea myself, and then we're going to get into some judicial examples, some times when the court considered the issue of derivative actions. Okay, so our first example today is the question of a derivative appeal. And if anyone needs the citation for these cases, that's fine. Just come and reach out to me. This one's Carpenter and Pioneer Park, a 2008 case of the New South Wales Supreme Court. This is an interesting question because it is one that concerns, is there leave for the applicant to go ahead with an appeal, right? Let's just work this through. We've got an applicant who applies to stand in the company's shoes. He does that. He brings the litigation. The company loses, and he wants the company to appeal. And he says, come on, court, give me permission for the company to appeal. Or more precisely, what he says is either you already gave me permission to appeal when you first gave me permission to go ahead with the derivative action, or in the alternative, you should give me permission to go ahead with the derivative action now. And so, look, there are a number of interesting elements to this decision. One of them is that before the court handed down judgment, another decision, this one of the Court of Appeal of New South Wales Court of Appeal, stood in the way of an applicant getting leave to pursue a derivative suit pursuant to the Corporations Act, meaning that the court had to go from its inherent jurisdiction. So the court had 2 questions to deal with. The first question was, all right, the first time that our applicant, that our shareholder, came ahead and asked for leave to stand in the company's shoes, at that time, did we give leave for both the initial proceedings and the appeal? And the court said, look, in short, no. When the court is considering whether to grant leave to bring a derivative action, the court is considering a very specific claim. And often it'll be a claim that is set out in some detailed legal documents that the court will work through in depth and in detail. And the idea that the court can simultaneously give its approval to grant leave for one set of first instance proceedings, and then also say, and hey, look, if there's an appeal, you can do that too, sort of strains belief a little bit. And what the court found, and found with some comfort and with respect in an outcome that is that might have been predicted, found that no, the initial leave grant was not a grant of leave that extended to running an appeal on behalf of the company. So the second question to turn to was, well, if there's no leave to run an appeal now, can we grant it? This is what the applicant asked. And the court said, well, okay, the company's in liquidation, So we need to think about whether we are going to exercise the court's inherent jurisdiction in order to go ahead with this. And what the court said, as you'll remember, is that we've got to think about solid foundation, attitude of liquidator, and practical considerations. Now, in relation to solid foundation, what the court said was, look, we just don't have enough evidence here for us to form a view about solid foundation. You just haven't told us enough about the appeal. We don't have the basis of the appeal. We might have been assisted by some pleadings, a court document setting out what the claim is. We might have been assisted by the opinion of a barrister, perhaps, who'd be sharing their ideas. And these things aren't before us, so look, there's not much we can say. Now, in relation to B, the attitude of the liquidator question, well, the liquidator said, look, I don't oppose a grant of leave per se, but I note that the applicant, this member, has bankruptcy proceedings that are already on foot. They haven't concluded yet. He's got a debt of $62,000, and there's no real protection financially if the company loses. So I'm not necessarily saying, no, don't do it, but there are these things loitering in the background. And then what the court did was turn to practical considerations. And as you might be unsurprised to hear, those practical considerations focused fairly and squarely on the financial position of the applicant, saying, you know what, this is not the financial position that we really like to see a successful applicant in, and so leave will not be granted, and so it was, in fact, not granted. Okay, that was our first example. Let's turn to our second. This is a decision of the Supreme Court of New South Wales, 2015. It's in the matter of Sundara, S-U-N-D-A-R-A. We've got an applicant who brings 4 applications for a derivative suit. The 4 applications relate to 4 different entities that the applicant says were there or thereabouts in relation to this same transaction that he complains of. What happened? A lender executed its rights following a failure in the borrower to make mortgage payments and sold the 4 companies' properties following that default. That makes sense? So 4 companies, they own some property, they fall behind on the mortgage payments, the mortgagee comes in, sells it to a purchaser, and the sale is fair and square. And what our applicant says is, no. The debts that arose in relation to those 4 companies were rightly considered as farm debts, and there was no mediation of those debts. And so pursuant to the Farm Debt Mediation Act, the purported sale to the third party is void because there was no mediation. And so it was a case worth arguing with respect, because the value of the claims together was about $50 million. So there was some substance, or I should say some substantiality, if there's a difference between substance and substantiality, in the issues to be argued about in this one. And so we turned to the 4 different corporations. Now, in respect to the first one, the applicant said, look, this entity is a farmer, right? It raises cattle, it grows olives, and it's part of a share farming agreement that includes a vineyard. And so that means that without a mediation, the sale of the property was a breach of the Farm Debt Mediation Act, and so it's void. And the court was satisfied, okay, there is a solid foundation for proceeding on that point. And the applicant also wanted to proceed against the purchaser, right? The person who bought the property from the mortgagee, from the lender in possession. And what the court said was no solid foundation for that. There's no reason why the company should be able to pursue the purchaser. What the court said was that the purchaser proceedings had substantial risks. and so leave should not be granted to pursue the purchaser. That was fairly uncontroversial. The applicant was able to establish good faith, was able to say, the court was able to see that the applicant was a shareholder in the company. So if things go well for the company, then things go well for the shareholder. And so the application being brought in good faith, the applicant wanted to improve his position, make his shares more valuable. The court said, yeah, look, we get it, and that's fine. But then there was a suggestion that leave be refused on practical considerations. And the practical consideration was that the applicant had assets of $6,200, credit card debts of $250,000, personal guarantees in the quantum of $45 million, a judgment against him from ANZ in the sum of $11 million, and a debt to the relevant lender in these proceedings of $23 million. And so the total of those top 70, and what the court said was, look, on the practical considerations, any indemnity from this person who looks to be underwater to the tune of 70 mil is going to be of very, very little value indeed. And so the application to bring the proceedings in the name of the first company was dismissed. And Mina asks a very good question here. Farm debts, what are farm debts? Mina, farm debts are debts as defined under the Farm Debt Mediation Act. And without diving into it too deeply, essentially the nature of that act is that debts incurred by a party who is undertaking farming work, so in this case raising cattle, growing olives, or entering into a share farming agreement, ought have an extra step before lenders can enforce against them. Basically, it's a bit more protection for people who are operating a farming business. In relation to the second company, the applicant said, yeah, that's a farmer too. And what the court said was, no, there's no solid foundation for that. And in any case, found that this negative 70 million financial position left the applicant too far underwater to be able to provide any meaningful indemnity. And so the application in relation to the second company fell away. The third company, similar, not a farmer. And in any case, the indemnity from someone so deep underwater was not of much value. Then similarly, we turn to the final company, but the final company is not in liquidation. It is only in receivership. And the court says, well, we are going to form the view, we're going to assume that the Corporations Act can deal with a company in receivership, but we're not going to decide on that point. And so in any case, working through finding that the applicant was applying in good faith, as we spoke about before, the court nonetheless found that the indemnity was so worthless because of the depth of the debt was so deep and profound that it was not in the company's best interest to be pursuing the debt anyway. And you'll remember that best interest is one of those Corporations Act tests when we're looking at the Corporations Act to think about a derivative action. And in any case, if we were looking at the court's inherent jurisdiction as opposed to the Corporations Act, the inherent jurisdiction would have the practical considerations outcome of that same indemnity being so worthless. So the practical outcome is the same. The question of how we get there is one that the court reaches on the basis of an assumption that the Corporations Act applies. And very nice comment, Mina. You're welcome for that explanation. So team, I'm going to have a sip of tea. And if you've got any comments to make or any questions to ask, do not hesitate with either comments or questions. Oh, and so all of these comments are from LinkedIn. If you're on Facebook or YouTube, can you just hit me with a thumbs up in the comments? I'm just trying to understand how this going live business works. So if you can share a thumbs up with me, I'd be very, very grateful. Okay, let us turn to our next case. This is a 2019 case of the New South Wales Supreme Court. It's called In the Matter of Global Advanced Metals. So we've got an applicant, and the applicant is a minority shareholder in the defendant, which is a producer and supplier of tantalum, which is apparently subject to argument. Now, what the applicant says is, hey, in 2016, the directors caused the company to sell this tantalum and some associated assets for 60 million, when they were really worth between 245 million and 900 million. And the applicant says, look, the directors breached their duties because they didn't think about this carefully enough. They didn't go into enough detail. They didn't give it enough critical thought. What they also did was they refused, the applicant said, or failed to investigate. Now, interestingly, and you can understand why the applicant might have got a bit grumpy about this, some of the assets that were sold for 60 million, so this is all 60 million of the assets, some of them were sold in 2018, 2 years later, for $1.15 billion. And so one can imagine why the applicant might have thought he, in this case, was on reasonably firm ground in arguing that they were sold at an undervalue. But the court had to think about this and said, well, yes, that is grounds for disappointment, but this argument is afflicted by a hindsight problem. So the court asked rhetorically, and I'm paraphrasing here, what relevance does a 2018 very high valuation, Terence, thank you for that strong arm emoji, which I appreciate. What value does a very high 2018 valuation, or, so the court said, a very low 2019 valuation have when we're trying to figure out what it was worth in 2016? So these very high, very low valuations in future years, yeah, we get it, but it's not actually compelling in an argument about the 2016 value. In any case, the court worked through what the applicant had to say. It's fairly uncontroversial. The company wasn't going to bring a claim. The company wasn't going to do it. Both parties said, yeah, that's right. The company's not going to do it. The second fairly uncontroversial point was that the applicant was bringing the claim in good faith. So not only was the applicant a shareholder who was likely to, enjoy an increased value in his shares if there was this money brought into the company, but he'd also spent a very significant amount of money in various court battles, getting access to documents, getting advice from counsel, these sorts of things. And so it was obviously brought in good faith. The court was comfortably satisfied of that. Thirdly, I should say, in the question of is there a reasonably arguable case, the court says yes, but the court was not satisfied that the claim was in the best interests of the company, right? Let's work this through. The court said, look, the conduct of ongoing business would be affected by these proceedings. The claim, quote, could not be described as strong, end quote. And there was a serious question about whether the company was likely to recover anything, if there'd even be any substantial money there. The applicant hadn't convinced the court there was a big pool of funds or there was enough money sitting there for the company to come and call upon if needed. And so in making that finding, the court said, look, there's going to be disruption and distraction if we allow this litigation to go ahead, because the defendants are the current directors and the current CEO. So it's going to really bubble over the way the company is going to be run. It's going to really up the company's insurance premiums and cause problems with lenders. In circumstances where the applicant did give an indemnity to the company about legal costs, but did not give an indemnity in relation to business losses, the court said, well, the company is going to be exposed to all these business losses and it's got no protection. So that's not going to be in the best interest of the company. And what the court also said was that the applicant hadn't really shown there was going to be a compensable loss and made a compelling argument that there was a loss the company had suffered that would ring or sound in compensation. Okay, hope that one helped. We are marching on, team, to our next decision, and it is the final part of our talk. And I'm going to have a sip of tea because I think we're staring down an early mark. So if anyone had a question or had a strong arm emoji that I really appreciate from you, Terence, or anything like that, please share that now as I have a sip or two of tea before we get to our final example. Oh, and sorry, one other matter of housekeeping. If you're getting any value from this chat, great. Thank you for coming. I'm going to do another one on LinkedIn, YouTube, and Facebook next Tuesday at 1 p.m. But if you're only just coming in now, or if you prefer a slightly later version, I'm going to give this same talk tomorrow, so Wednesday, 8 p.m. Sydney time. And if you're inclined to join me at Wednesday, 8 p.m. Sydney time, it'll be a bit more of an 8 p.m. vibe. I won't be drinking tea. I might find a cheeky whiskey or a cheeky glass of wine or something like that. We'll talk about similar subject matter, but we'll be on Instagram. And the Instagram account, if you're interested, is Coffee and a Case Note, COFFEEANDACASENOTE. Okay, let's turn to our final example. This is a case called VICAD Pty Limited, Supreme Court of New South Wales in 2011, and it is a derivative suit arm of a fairly complex testamentary or succession dispute in a family. We've got an applicant who is concerned about the status of a farming and grazing company that is being operated by some siblings. And those siblings are directors of the company. And what the directors are doing is occupying the company's reasonably valuable land without paying rent. And that unpaid rent might have sounded in several hundreds of thousands of dollars. Now, the applicant further said that, look, the sole surviving director, the only director who's alive, has lost capacity, meaning that there are no directors of this company who have any capacity to chase these debts. There's no one who's got a basis for doing it. And there are further complaints that assignments of directorships and these sorts of things were tainted by this director having lost capacity. And there are questions about undue influence and these sorts of what might be called elder law issues as well. And so this is the background that the court is confronting when they're coming to this matter. The court noted, firstly, as you and I now know, that there is no discretion for the court to withhold leave to pursue a derivative suit if all the criteria have been met pursuant to the Corporations Act. So what the court says is, yeah, okay, well, let's work through those criteria and see where we end up. So the court finds that, yes, tick, it is unlikely that the company is going to sue these directors. The court finds that, well, yes, tick, the application is brought in good faith, that second element, notwithstanding the fact there is animus and malice and anger. There is nonetheless no alternative claim available to the shareholder, and the shareholder will stand to benefit if the company is able to recover this unpaid rent. Third point, the applicant did provide an indemnity to benefit the company, meaning that the proceedings are for the benefit of the company. Charlene asks an excellent question here on LinkedIn. Charlene says, breach of director's duties, ? Yes, Charlene, that is precisely what is alleged, that these directors failed to pay rent in breach of their director's duties. Spot on. The court noted there was a relatively low threshold for this serious question to be tried point. And so the court was satisfied there was a serious question to be tried, and there was the provision of notice. And in the circumstances, what the court did was grant leave for the company to pursue the directors by way of derivative suit. And Charlene asks, under the Corporations Act, short answer, Charlene, is yes. And then potentially, I've forgotten which section they applied for. It'll be one of those 180, 181, or 182 sections there. And so, as I said, team, our talk today is divided into 3 sections. We're going to talk law, going to talk examples, going to talk practical suggestions. We've done the law. That was the hard bit. We've just done the practical examples that I hope we've just done the worked sort of examples that I hope was of value to you and of some interest. And now we're going to close off with just a few practical suggestions. And we are staring at an early mark. We're staring right down the barrel of an early mark, so I'm sure it's going to go well. Now, when you're advising you're going to be considering a lot of different issues, and things are probably going to be moving reasonably quickly with a number of different parties involved, many of whom have strong feelings and commercial motivations to go with those feelings. And I'm not really a checklist person, and I don't necessarily encourage you to be a checklist person, but I thought I might just work through some issues for you to take a look at or have a think about when you're thinking about how to best advise your client, or if you are the relevant person, how to best think about the issue that's in front of you. So the first question you might ask yourself is, have all reasonable avenues for negotiation been exhausted? A derivative suit should not be taken on lightly, and should not be taken on, I say, with respect, unless we can get a good answer to that question. Well, the next question might be, is there an alternative claim available to your client? That means your client doesn't have to stand in the shoes of the company, that she or it or they or he could instead bring something in her or their or its or his own personal capacity, rather than having to go stand in the shoes of the company. That should be a question to ask. Does your client have standing? Is it a member or former member? Creditor in the case, in certain circumstances, inherent jurisdiction circumstance, for example. If you're going to bring a derivative suit, have you got draft pleadings to put in front of the court? Have you got evidence to put in front of the court? Or if you don't, have you got a path to get that evidence? Have you got a plan? Have you obtained a barrister's advice that you can put in front of the court and say, well, here's what some counsel or a barrister have to say about things? And then more generally, if you're thinking about a derivative action for a solvent company or a company in receivership, probably, have you worked through those 5 Corporations Act Section 2372 factors that are, let's see if we can remember them together. Let's do it. We start with, is the company going to bring the claim? Do we have evidence of that? An argument about that? Do we have a good faith evidence and good faith argument? Do we have serious question to be tried evidence and argument? Do we have best interests of the company evidence and argument? Often that will be served by an indemnity from your client, an indemnity from the applicant. And have we provided notice, or alternatively, do we have a path around having to provide notice? In the alternative, if we're talking about a company in liquidation, have we addressed those 3 inherent jurisdiction questions? Those questions are, look, is there a solid foundation for the claim? What is the liquidator's approach, liquidator's view on the claim? And then thirdly, what are the practical considerations that ought to be borne in mind? And so, thank you very, very kindly for your time. We have comfortably got in for an early mark. I'm going to loiter around for a moment or two in case you have any comments you'd like to make or any questions you'd like to ask. And then my plan is to get out of your way. Before I do, I'd like to invite you to come along next week, 1 p.m. next Tuesday. I haven't decided the topic, but it will be corporate, commercial, litigation-y stuff that I hope you're going to find of value. So we'd love to see you next Tuesday at 1 p.m. Or alternatively, or as well, love to see you tomorrow night, Wednesday, 8 p.m. on Instagram. Coffee and a Case Note is the Instagram account. Jun, thank you for your very, very kind comment down here. Jun, I'm just going to read it so it's on the record. Jun says, incredibly value as always, James. Thank you, Jun. I'll take that. I think that's incredibly generous. Very, very kind of you, and I'll move out of everyone's way. Thank you all for your time, and look forward to speaking with you again soon. Thanks so much.